Good evening, ladies and gentlemen. Welcome to Burn the Corporate Fiction and Happy Halloween, or Samhain, as the Druids would call it. I hope everyone is doing well. So, yes, there's a lot going on. I apologize for not streaming for over a week. I'm preparing for the International Truth Expo. I'm presenting down in Quartzsite, Arizona, November 8th at 10 o'clock, if any of you are going to be able to make it. Yeah, pretty much had my time tied up preparing for that. But man, people are flipping out about this EBT stuff. I've been seeing some very erroneous posts, especially on Facebook, about what exactly funds EBT. I'll be covering that towards the end of this stream. But before that, I decided, the last stream I had covered thoroughly destroyed the 14th Amendment, really. That is the linchpin of this entire trust indenture system. And as I was explaining, we were the pilot program for international slavery in a trust indenture. So it all basically launched from the United States in the 30s, and then by making the dollar the global reserve currency, which is really just a Federal Reserve note, allowed everyone else to tag on to what we were doing, offer benefits in exchange for administrative control of their estates. Of course, mortgaging that to the central banking cartel to essentially place all of your property, including your body, in trust, and leaving you with only equitable rights to even yourself, just your own body. So, got to wear a seatbelt. Don't put drugs in your body. Don't do this. Don't do that, little infant. We have to preserve the property until the heir comes forth and claims it. So I figured on this stream, I'll go into, what is law? A lot of people seem to have trouble understanding why statutes, codes, canons, rules, regulations, why they are not law, yet they're still enforced upon you under the color of law, and how that happens. People, so I hope to clarify that a little bit by the end of the stream today. So let me say hi to those of you who have made it in the chat already. We have Faye. We have Pat, first and foremost. Good to see you, man. And he said he was sharing out the stream. I appreciate that. Faye, a fellow member of the Jurists Society. Glad you made it. I know she works a lot, usually late. FE Nation's watching, another member of the Jurist Society. And Say What, yet another member of the Jurist Society. Good to see you guys. I'm glad you made it. Dirty Ketchup is in the chat. Good to see you. Jacob Mendez, another jurist. Good to see you. Stephen Nichols and LJ. So I'm glad you guys made it. Now, if I do not, continually say hi as you guys come in, I do apologize. I will try to glance over at the chat. But again, this is going to be a heavy topic requiring a lot of focus and explanation. So please forgive me if I seem a little detached from the chat. I will try not to be. So let's get right into it. What is law? Man does not create law. For atheists, this is almost impossible to grasp. But then again, atheists will never be able to actually study the law to any sort of, deep level, because in order to do that, you have to come to terms with the fact that the fount of all authority is Almighty God. It just is. And law is biblical. Even Brandon Joe Williams begrudgingly admits that, at least in my opinion, he seems to be, begrudgingly admitting that all law is biblical, especially trust law. It really is. And it comes from the concept of the very first trust, right? And that trust is God entrusted you with free will. And with that free will, you are entrusted to follow his will, his law, right? Honor him, and to conduct yourself according to the law and all of your dealings, and honor your word, right? And that's the foundation of common law. And I'm gonna prove it to you. So it's not just me saying this. A couple hundred years ago, this was common knowledge amongst people who studied law, right? Some of the greatest jurists of all time, like William Blackstone. We're going to take a look at some of his work today, Blackstone's commentaries. At the Revolution, any colonists who were worth their salt, who knew what they were talking about, had two books: the Holy Bible and Blackstone's commentaries on the laws of England, and 4 books, right? So I've read 3 out of 4 of those books. I think that's pretty good. The 4th one I didn't really feel was applicable at this point in time, so I skipped it, but maybe I'll go back and read it at some point. So man does not create law. Therefore, he cannot legislate it. The one and only law is not written. It's written about. The law is discovered, observed, and revealed. The application of law to a society is called Jus Commune, or the common law. Okay? So there are many treaties all throughout history that reflect this understanding that man does not write law, okay, if they do not outright admit it. And some of them do, like especially in Blackstone's. Says, so because of this, laws made by man must always assume another name, such as statute, code, rule, regulation, canon, right? Now, the Pope had said he called his laws canons because he didn't want to offend the king, but the king doesn't call his laws either. He calls them statutes, you know, Second Richard statute, right? Or First Charles statute. That's how it's, you know, that's how you would cite it. At least I think it's somewhere, either it's First Statute Richard II or something. It's written like that, citation. I don't know. I'm not English. I don't look at their law books too much, but I have studied the history of English law to know what has happened here. So it always has some sort of prefatory statement before it. Man's law does. Statutory law, administrative law, contract law, right? So Uniform Commercial Code doesn't even say law because it's not, but it basically is the law merchant. And I'm going to show you how, well, you guys know if you watch my last stream, the 14th Amendment is definitely the linchpin of how they do this, but why? How does it work? They have to either mediately or immediately trace their law back to the original law, or it's of no force, right? So let's take a look at this real quick. Share the screen with you. And this right here is actually a great story that pertains to the whole EBT welfare thing about Davy Crockett, one of our early congressmen, and what he said about taking from one to give to another. And charity should be voluntary, but that's not what we're looking at right this second. We are looking at the Heart of Blackstone. So go down to page 15 here. This is written, just so you guys know, this isn't just written by anybody. This is a treatise on Blackstone's commentaries, right, of what this lawyer believes is the heart of what he was trying to convey. Her name's Nanette B. Paul. She was a lecturer on law in Washington College, Washington, D.C. So if you know, they don't just choose anybody to give lectures on law. She's a fairly authoritative source. Even though I do not believe they teach lawyers this stuff that I'm about to show you these days, because otherwise it would kind of ruin their whole scam that they got going on, their whole inland piracy scheme. But she says the common law is grounded upon the general customs of the realm and includes in it the law of nature, the law of God, and the principles and maxims of the law. It is founded upon reason and is said to be the perfection of reason acquired by long study, observation, and experience, and refined by learned men in all ages. Well, do you notice what it does not say? Nowhere in there does it say that it's created by man. Nowhere. Because man does not create it. It's either revealed or discovered and observed. Revelation would obviously be like the Mosaic precepts and the Ten Commandments. That would be divine revelation. But even when you study that, you'll find that it's in accordance with the common law. So to get even more specific about how this law, the one and only law, is paramount over all other forms of statute, code, etc., we'll go to Blackstone himself, which, let's see, I have that right here. We're going to go to page 47, which is right up here, of book 1. So this is Of the Law in General, is what this section's called. Very good book. If you have not read it, I advise everyone do read it. And every time you do not understand something that he's saying, like he brings up a certain concept or situation or word that you never heard before, look it up and learn it, because it's going to expand your understanding of the law exponentially, right? And there's so many things they've taken from our language, which has really limited our ability to think and to comprehend certain things that are being done, because these concepts are foreign to us. They're unfamiliar because they're not taught to us in school. They say ignorance of the law is no excuse for breaking it. And I say, then why do they not teach the law in school? Well, welcome to law school. This is Burn the Corporate Fictions Law School, right? All right, so 48, I think, 47, sorry, page 47. It's right here. He says, The law of nature, this law of nature being coeval with mankind. Now, coeval means created at the same time or in the same period. So man didn't create law, and Blackstone himself is telling you that law was created along with man. So the law of nature being coeval with mankind and dictated by God himself, okay, is of course superior in obligation to any other. It is binding over all the globe. And yeah, we know he believed it was a globe, whatever. Anyway, it's binding over all the globe and all countries and at all times. No human laws are of any validity. This is so important. No human laws are of any validity if contrary to this. And such of them as are valid derive all their force and all their authority immediately or immediately from the original. So for man's law, which is not law, but it's rules, regulations, statute, code, canon, whatever, right? Even though I'm sure the Pope would like to think he's a god in some respects, right? Because he's the vicar of Christ. Anyway, in order for it to be valid and of force, it has to be able to be traced back to either immediately, directly back to, such as a statute that says do not kill people unless in self-defense, right? That's immediately traced back to the law because, you know, you can't kill people. You can't, you know, unless it's in self-defense or as a punishment for a crime after trial, et cetera, right? Immediately, meaning that there's a middle factor, like a mediating factor there that allows them to still trace it back to the law and therefore give it the color of law, force of law, would be like administrative law. Okay, so administrative law is not law, but common law recognizes the need for a body of jurisprudence to be created to administer the estates of incompetents, paupers, and minors, people who are presumed not to have free will. And we're going to get into that. But let's read this a little bit further. He says, there's another part where he says, it's just down here a little bit. Upon these two foundations, the law of nature and the law of revelation, depend all human laws. So I had somebody in the comments say to me, the law was revealed, it's not discovered. No, it's both. The law of nature is not the same thing as divine revelation. No, divine revelation and the law of nature are in accordance with one another, obviously. The law of nature is what we observe and then put into practical use in society. We apply it to society. So dependency is a very good example of what I'm talking about. We're all dependent creatures upon God because we couldn't exist without God. Therefore, that's why God's law is absolutely paramount to anything else. And that, like Blackstone said, it's superior in obligation because when you're dependent on someone or some entity, you must conform to their will to the degree in which you depend on them. And the Jurist Society members know this very well. We got Mojo in the house. Good to see you. And Wayne Sands, Section 19 of the Criminal Code of Canada. And Carson Russell says, do you litigate or help people as a counselor at law? Need some help? Check out my video pinned on my page. Well, I will after this stream, and I will see what you're talking about there. So anyways, since we're dependent upon God and we have no choice but to be dependent upon God, we must conform to God's will. Okay. Well, they took this fundamental observation that's not in the 10 Commandments, but that is an operation of natural law and therefore part of common law. They took this and applied it to society and saying, well, if we're all dependent on God for that reason and must subject ourselves to his will because of that, then these paupers who can't take care of themselves, who would starve to death without our assistance, must also do the same thing and settle their estates with us and come under our administration and conform to our will. Since they cannot make themselves productive, we will make them productive. And of course, take an administrative fee for our troubles. We'll tell them how to live their lives, how to use their property, et cetera, et cetera. That's what the Settlement Acts and the Poor Laws of England were all about. And that is an application of the common law to take these people out of law and into administrative regulations. And the law recognizes that as long as the grounds upon which that is done were not fraudulent or coercive, like in our case here in the United States, or pretty much really anywhere that they committed fraud, collusion, coercion, and misrepresentation of material facts by agents of the state to mislead people into believing that signing these contracts or even just being a United States citizen in the first place is actually a requirement, when in fact it's voluntary, and we can prove it via case law, as I did in my last stream. Not going to get too much into that on this stream, but go watch the last one where I said, breaking their counterfeit system. That's what it's titled. Anyway, so he says, upon these two foundations, the law of nature and the law of revelation, depend all human laws. And this is Blackstone's commentaries, if you're just tuning in from 17, I forget when it was. It's just before the creation of the Republic, late 1700s. It says, that is to say, no human laws should be suffered to contradict these. There are, it is true, a great number of indifferent points in which both divine law and natural leave a man at his own liberty, but which are found necessary for the benefit of society to be restrained within certain limits, right? And herein it is that human laws have their greatest force and efficacy. So that's what and they're not laws, but statutes, codes, stuff like that are supposed to be for the regulation of, say, commerce, for instance, or obviously the regulation of persons under administration. And so up here he says, the doctrines thus delivered we call revealed or divine law, and they are to be found only in the Holy Scriptures. These precepts, when revealed, and now mind you, Supreme Court justices and judges cite Blackstone to this day. This man is highly respected in the field of law, and these books are legendary. And this is what he's saying. So you don't have to go, oh, God's not real, or oh, you're thumping, or no, I'm telling you, I'm reading this right out of his work. This is an operative understanding. When you study law, you have to start at the fount of authority. Well, where does authority come from? Well, it only comes from Almighty God, right? And then it has to follow channels. And originally in every other country in the world, this was kings or judges or elders or people appointed by God to be in charge. Here in this republic in the United States, for the first time in history, the people were enshrined as the sovereignty and co-tenants in the sovereignty, right? And above the government, like we read in Chisholm v. Georgia, that the government stands in the same relation to its sovereign as the regents of Europe stand to their sovereigns, meaning it's our subject. And because we were sovereign, we are sovereign as state citizens, but the 14th Amendment citizens not. Because we are sovereign, we had allodial ownership of all of our property, right? And therefore, we were only subject to the common law, because that's the one law that you always have to follow. It's based on divine revelation, natural law, or the law of nature, nature's God, which you have no choice but to follow. And like Blackstone says here, he says these precepts, talking about divine revelation, when revealed, are found upon comparison to be really a part of the original law of nature, as they tend in all their consequences to man's felicity. Now, felicity basically means happiness, prosperity, joy, right? And what he's saying is that whether these were revealed or not, man would find that when he refrained from doing the things that the Ten Commandments says not to do, even if it had never been said, when he does refrain from doing those things, it is essential to his happiness. For when he does engage in those things, he does injury to himself. And that's how the law is interwoven into like an intrinsic tapestry of nature. Okay. And it's written on your heart. And you really don't have to be told that violating the free will of another living soul is wrong. You don't have to be told that. When you're a kid and you hit another kid or take something from him and he starts crying and you feel bad. Unless you're a psychopath, don't get me wrong, psychopaths exist, but the rule's never the exception. The exception's never the rule. Okay. So Blackstone himself tells you what the origin of law is and what common law is founded upon, right? So let's see here. The law is written on the hearts of man as the intrinsic tapestry of creation, obedience to which is essential for the happiness and prosperity of man. All laws of men inconsistent with this law are deemed to be of no force and effect, unless they can immediately be traced back to the one and only original law, as with administrative law. So man, being a corrupted and imperfect being, has always lusted after the power to create law. since the first city of Enoch was established by Cain. And yes, this does go back that far. That is the true power that the wealthy elite want, is the power to be able to create and enforce law, to be able to impose their will under the color of law upon other men and subjugate them, right? That's what they're after. And that's what they're very close to getting. So since the first city of Enoch and Cain, I believe they were aided by the spirits of darkness, right? And they developed a method of inverting the original trust to place themselves in the seat of the lawmaker. But in order to see how that's happened, we have to take a look at what are rights. Okay, so everybody talks about, I have the right to do this, I have the right to do this. Let's take the food stamp people, for instance. Do you have a right to food? No, you don't. That's not a right. You don't have a right to food. You have the right to acquire food. You don't have the right to just be given food, because generally that has to be taken from someone else. The government has nothing of its own. Okay, so that's not a right. Do you have a right to health care? No, that's not a right. You have a right to acquire health care. You have a right to be able to learn how to take care of yourself. That's a fact. But you don't just have a right to health care. So people are very confused on what rights are. And they think that the benefits that the government offers them to enslave them are actually rights, because that's what they're called by the government. They're called civil rights. But civil rights are not rights. They're privileges. And they always come with a set of conditions. Okay. And privileges can be taken away at any time. So let's talk about what a right is. A right is called a right because it's universally recognized to be good and true. It flows forth from and remains consistent with the law. And as such, it is inherent to all mankind in a state of nature. We just take a look at Cruden v. Neal. Let me see if I have this pulled up real quick, or I can pull it up if I don't. So Cruden v. Neal. And we'll just go to, like, say, Justia or something, right? Or Case Mine. Case Mine will work. Case Mine's a good resource. All right. So Cruden v. Neal is essentially about a British subject who was being tried for being a traitor, essentially. And he was found not guilty because he wasn't necessarily a traitor. And why was he not a traitor? Because when he was siding with the British, there was no such thing as an American citizen or a United States citizen or a citizen of one of the states, because they had not been formed yet, right? So like it says here, it says in the War of the Revolution that he had attached himself to the enemy. That's what they were trying to accuse him of. And so the opinion, the judge who gave the opinion in this case is actually a very wise guy. I've just got to find where it says it real quick. They're really not going to say it. Oh, this is a really shortened opinion. That's dirty. This isn't the one we want. I mean, it is the case we want, but that's not very helpful for us there. So usually you could pull it up on Justia, but I'm surprised it didn't just pop up there. All right, we'll just go to Four Winds, whatever. This is actually a court case you can look up on Harvard Case Law Access Project. So it's a real case. I never show you guys anything that isn't an actual case. Let's see if I put in Justia. They take it off Justia? They probably really don't want people to know this stuff. Well, here. Cruden v. Neal. That's weird. I've looked at this on Justia before, and I don't know why it's not there. But anyways, let me stop digressing. We'll just go to any one of these. Doesn't really matter. So, and this applies to us very much so because they've silently subverted and changed our form of government. Okay, so it says right here, and I'm going to highlight it, even though it's already highlighted. It says that the majority shall prevail is a rule posterior to the formation of government. It comes and results from it. So the whole concept of democracy comes after a state of government. He's talking about during the Revolutionary War, right? It was just British subjects against British subjects. It was really a civil war. And that's what it was referred to as all the way up through the 1800s. It was called the First American Civil War. You know, obviously after the Second Civil War happened, they still referred to it as the First American Civil War. And so he's saying that the majority shall prevail is a rule posterior to the formation of government and results from it. It is not a rule binding upon mankind in their natural state. There, every man is independent of all laws except those prescribed by nature. He is not bound by the institutions formed by his fellow men without his consent. This applies to us to this day, because between the 30s and 70s, they silently, well, actually at the Civil War, a de jure government adjourned without a day. But even beyond that, it still kept up the pretense that it was de jure government, while it silently expanded the 14th Amendment to include everyone and bring them under the federal corporation as wards under administrative guardianship, so they could mortgage you to a central banking cartel eventually in 1933. But anyways, 1933 to the 1970s, they instituted the Federal Uniform Commercial Code, the Federal Administrative Procedures Act, the Emergency Banking Relief Act, the Trust Indenture Act, the Housing Act, the Investment Company Act, and a whole slew of other federal acts that then, throughout the 60s and 70s, the states adopted, silently supplanting the original de jure state governments with quasi-corporate administrative agencies that are now just administering the estates of infant foreign residents that are engaged in commerce on behalf of their corporation, the United States. And I can prove all of that. I especially proved it in the last stream, so I'm not going to get into that too much. But that's important, that so because they changed the form of government silently, subversively, without our consent, right, we need not be bound to these institutions, because these are not the original institutions that our ancestors had agreed to live in. That was the original, constitutional republic. Really, it's the Confederate Republic is how it should be referred to. But too many people are ignorant of the history of Civil War and think Confederate means racist or something. But no, all of the states were Confederate. Every single one. Michigan is a Confederate state because Confederation is a style of union. And and it just merely means that the sovereignty resides within the state. And it's contradistinguished by a corporate union, which we now are, where all of the constituent parts come under the federal as subsidiaries. Just same way all the enfranchisements of McDonald's come under the headquarters of McDonald's. Right now we're a corporate union, but originally we were a Confederate union. It's in Penn Hollow versus Stone's Administrators. When a union is Confederate, not corporate, the sovereignty resides within the state. And the state did reserve all powers she did not expressly give to the federal government via the Constitution. And a state cannot cease to be sovereign except by its own act, and sovereignty can only be asserted upon a clear title. I've read that case quite a few times. So, in Michigan, and their address accepting their entrance acknowledging their entrance into the union, they say that they're solicitous to prove to her desire to promote the peace and tranquility of the Confederacy, or the peace and harmony of the Confederacy, rather. But anyways, so yeah, very good case to be able to cite, just like Chisholm v. Georgia we went through last time. So all rights, now this is the important thing to realize about rights. All rights are relative to property and the relationship one has with the property, okay? The only right that you have that is not derived from property is the right to acquire property, which that comes from God. That's a sacred trust between you and God through the vehicle of your free will, which we're actually going to get deeply into that here shortly. But all rights are derived from property and are determined by your relationship to property. In fact, the Latin word for estate is status or status. Everybody knows the word status, right? Correct your status, that whole thing. Status, literally the relationship one has with their own property, or what they think is their own property, determines their status. Okay, I'll get into that more in a little bit. So all rights are relative to property and the relationship one has with property. There are many species of rights, and I'm not going to get into all of them right at the moment, but primarily you can reduce them to two fundamental categories: lawful rights and equitable rights. Okay, but equitable rights should be more accurately termed privileges, because they're not actually rights. They're usually privileges resulting from some sort of trust situation, some sort of agreement regarding the use of property held in trust right? Where the superior interest holder dictates the rules that come with using the property, say like your automobile that they like to call a motor vehicle. Why does it have the state's name on it, right? They tell you how to use it. They tell you how fast to drive it. They tell you under what conditions you can use it, and you have to pay for permission to use it, right? Those are all your equitable rights to your automobile. You think you actually own that thing? No, not so much. It's held in trust as collateral for the public debt. So equitable rights should be more aptly termed privileges, but just for the sake of simplicity, we're going to call them equitable rights, okay? So lawful rights are derived from absolute ownership in property. This type of ownership is termed allodial. Okay, it actually comes from the Norse. Okay, it has the same root word as the word oath. It comes from the rune othala, which is a concept meaning ancestral inheritance. It essentially represents an oath, a pact between you and the creator, the divinity. Even though the Norse obviously had many pagan, it's still the same concept. It was because man cannot actually own land, right? He can only hold dominion over land, and that's what allodial title actually represents, is absolute dominion over land granted by God, right? Made via an oath between you and God to be the caretaker of the land and to have your heirs be the caretakers of the land, forever. And in this republic, we have allodial title. 100% have allodial title. I'll show you. And we would have to, because we weren't subjects. We didn't create a new law in the United States once we gained our independence. We continued using the same law, which is the only law, the common law. The only thing that changed is we were no longer subjects. So we had absolute ownership of land and all of our other property. And when you have absolute ownership of land, nobody can tell you what to do on that land or with that land or any of the property that you own allodially. Okay, that you hold a allodial title to. And if they could, then you do not have an allodial title. Here, they were called land patents. But I'm not just saying this. I, of course, will prove it, as I always do. And I'm sure that I have it pulled up somewhere. Wisconsin Constitution, where are you at? Thought I had it pulled up. It's kind of annoying. Hold on. Well, I'll just tell you where it's found, because I thought I had it pulled up, but apparently I don't. It's Article 1, Section 14 of the 1848 Wisconsin Constitution specifically says that all lands within this state are declared to be allodial and feudal tenures are prohibited. You can look this up yourself. It's Article 1, Section 14 of the original 1848 Constitution that says all lands within the state. Oh, here, I found it. Let me do this. I'll just pull it up here. And there you go. All right. So section, it's kind of a grainy photocopy, but this is Wisconsin Constitution, 1848, right? Says in the year of our Lord, 1848, you go down to Article 1, Section 14, and it says, all lands within this state are declared to be allodial and feudal tenures are prohibited. That's so important because of what I'm going to teach you today about how they've subverted law and your sovereignty and inverted it essentially to try to make themselves gods on earth. Okay, but that's very important. Is all lands within the state are allodial and feudal tenures are prohibited. The reason being is because all states enter into the union on the same footing as the 13 original states. And so if that was not the case in all of the original states, then there's no way that Wisconsin could enshrine that in their fundamental document, which I'm sure pisses the bankers and the Bar Association off very much that they did, but they did it. And so now you can prove it to any lawyer, any judge, or anybody that tries to say there's no such thing as allodial title. Yes, there is, 100%. And you know what's so funny is when you type allodial, like type allodial into Google right now, it'll tell you that's not like you're misspelling a word. It's not a word. But then you hit enter and it tells you what allodial title is. That's how they're trying to remove that fundamental concept from the public zeitgeist. They're trying to remove that from the public consciousness. They don't want you to ever even consider or conceive of anything allodial. Okay. So lawful rights are derived from absolute ownership of property in it, and that's called allodial title or perfect title in the Roman civil law system. But you don't want to ever be in that system, even though that's what we're in right now. That's what you want to get out of. So lawful rights are enforceable at common law, the violation of which is a trespass upon the free will of another living soul. That's why. It's because that's the only things you can enforce at common law are actual harms. So when we watch people win court cases, right? And in fact, I can show you a court case here. Actually, yeah, I think this would be a good example. So here, let me stop sharing this for a second. This guy, if you've never heard of him, I'm going to show you a victory. Okay, I'm going to show you guys a victory, the excellent victory. This guy kicked ass because he took this fundamental knowledge of how law works and he brought it into the courtroom. And in fact, I think I'm going to use the YouTube one that somebody had sent me. So let's do that. Let me go. Sorry, guys, I didn't think to show you this until just now, but I do think that you will all benefit very much from this. You want to see somebody just stump a judge. There's nothing they can do, right? Who sent it to me? Not that. It's got to be up here. Is it Jeff? I think it might have been Jeff. You know what? We'll just go with the Facebook one. It's a little hard to hear, so I think they messed up the audio on it, but I'll translate it for you guys so you can see so you know what he's saying. I'll go to this one. There. Pause it. All right, let's display it. Okay, here you go. Let's make sure it's not. There we go.
For the record.
So she calls him up and she says, were you able to cure your license with the DMV or is there still a hold on it?
My name is Ryan Thor. I'm the living man. I am not the entity known as Ryan Michael Thor, just to clear that. I am here on special appearance under threat, duress, and coercion to challenge subject matter jurisdiction and also personal jurisdiction as well. I filed my paperwork for you on Friday, and the clerk illegally denied it. I went again this morning and filed my paperwork again for you. The clerk again illegally denied it, even though I gave her a notice telling her it's a felony for her not to accept my paperwork. And actually, it's in law, it's considered filed when I gave it to her. Okay. So therefore. What do you want to do today, sir? Well, Your Honor, I mean, I'm going to have to ask a few questions.
So she asked him, what do you want to do here today, sir? And now he's going to say, well, I got to ask a few questions. Always ask questions when you're in the courtroom. Never make statements. When you make statements, you bear the burden of proof. Whoever makes the statement or the claim has to prove it. It's just like a debate, right? So a lot of you I know are in the flat earth community. And if you watch these debates, you never want to make a statement. You want to ask questions. You place the burden of proof on the other individual.
First, which first of all is I need to understand the nature and the cause of the charges against me, as well as I need to know, is this a civil jurisdiction or criminal jurisdiction?
Okay, it's criminal jurisdiction.
Criminal.
Okay, so he said, is this civil or criminal jurisdiction? She said criminal. Technically it is because it's under special maritime territorial jurisdiction in the United States, and it has to be. And I can actually prove that. And I'm one of the very few people, I'm not trying to brag or anything. I was so excited to share it with the Jurist Society when I finally, after all these years, figured out how they brought maritime admiralty inland, other than the fact that being a U.S. citizen engaged in commerce within the state is technically interstate commerce. Placing it under federal jurisdiction is one of the layers that they use. But the other layer that they use is, believe it or not, almost every state in the union since the early 1900s has adopted port districts that overlay, and they're private corporations that are imbued with governmental authority. And they almost all of them say for the purposes of encouraging or improving trade and commerce and providing business opportunities and getting buildings ready for international investors and this and that. But port districts like Michigan has been cordoned off entirely into port districts. Utah, port districts. These entire, like, okay, yeah, Michigan's got Great Lakes, so cool, sure, you'll have port districts. But why does, say, like an entirely landlocked state like Utah have it, or Nebraska? And so the very few states that do not have port districts, they have ports of entry that are ran by the Department of Homeland Security and Border Patrol, CBP, right? Because that's under DHS. And by doing so, they're able to essentially make the entirety of the United States territorial waters, which is special maritime jurisdiction. So the special maritime territorial jurisdiction is delineated in Title 18 of the United States Code, which is crimes and criminal procedure. And that's because they consider all traffic infractions and all of this stuff to be violations of that special maritime territorial jurisdiction. That's how they're able to essentially determine all vehicles are, or all automobiles are essentially vessels upon the seas of commerce, even though they call them vehicles, right? And so I usually never brought this up because no judge will ever admit it, but now I know where the nexus is, so I can prove it. Yes, you are doing this, okay? Because you're operating under the commercial territorial jurisdiction, which is under the direction of the port districts. So I found that interesting piece of information. But he asked her, is this civil or criminal? She says criminal because, and that's why they always put traffic court in the criminal division of the Roman civil law BS, is because it's considered a maritime violation.
Traffic infraction court, so no possibility of going to jail on any of this. You've settled one of your counts.
So she said it holds no possibility of going to jail. You've settled one of your accounts, probably because he posted a bond. And so they're saying that it's, they're going to apply that. So watch.
Proof of correction on August 26, 2022, or Ryan Michael Thor did. Are you saying that's not you?
Ryan Thor is the living man. Ryan Michael Thor is the defendant in error. It's the artificial person. So thank you, Your Honor. Let the record of the court show that the action against me is criminal. And now I have another question, because the Constitution grants us two different criminal jurisdictions, okay? One criminal jurisdiction is under the common law, and the other is under the criminal jurisdiction of admiralty or military tribunal venue from Article 1, Section 8, Clause 17
That's right.
of the Constitution.
That's right. And that's just the U.S. Constitution. Technically, you should use your state's Constitution, but she has a U.S. flag right next to her with the military fringe on it, so, which is a mutilation. One of the Jurist Society actually found all of the executive orders and statutes and whatnot that prove that is a military flag, essentially. But without going into that, he says, is this an art? So this is a criminal court. The Constitution only provides for two types of criminal court. The federal Constitution does, right? One is the Article 3, Section 2 common law courts, where it says that that they'll have jurisdiction in all cases at law and in equity. The other type of court is Article 1, Section 8, Clause 17, military tribunal. And he just asked her that question. That's a brilliant question to ask, because now she's cornered. That's checkmate. So she's going to try to answer a question back to him, or ask a question back to him to place the burden back on him. Watch.
Well, I need to know which of these two jurisdictions that you intend to try me. It's very important because they're done different ways. The rules of civil procedure are very different in a criminal jurisdiction, obviously for common law, and a military.
Civilly, no one's asking you, no. So we just need to show, were you able to cure your license with the DMV, or you don't know?
See, she asked another question. Were you able to cure your license? Because if he answers any of those questions, what he's doing is challenging jurisdiction. She cannot proceed until she has established jurisdiction by getting him to state his name for the record, right? If you do that, then your automatic, a general appearance is consenting to their jurisdiction, their equity jurisdiction. So he's challenging it, and he's asking her, you know, hey, the nature and cause of the charges against me, what type of court is this, civil or criminal? Is it criminal? Okay, well, there's two types of criminal courts. Is it Article 3, Section 2, common law? And if so, I need to see my victim. I need to see a verified complaint, signed sworn affidavit with a witness. Otherwise, there's no reason for me to be here. But if it's not an Article 3, Section 2 court, then I need to know how I ended up in an Article 1 Admiralty court. So.
Again, I need to get these other questions answered. I need to know what the jurisdiction is, and I need to know also who the injured party is. You know, the nature and cause of this. I need to know who the injured party is.
Okay.
I need to know who's bringing the claim.
How about, okay, the state is, so here's the deal. Do you want to have a trial date? I can give you many trial different dates, and you come in and you can ask all the questions, and they have to prove the charges against you, so.
Thank you, Your Honor, but I don't think you'd be violating your oath of office by doing your duty under the Constitution. Okay?
Mr. Thor, I'm gonna have to come back to your case, because I have all these other cases, and I'll take all the time in the world to do, because you,
I-
see you add on today? Wait, what's on the calendar?
You know, Your Honor, I just motioned for dismissal because if this is a criminal jurisdiction, as you're claiming, I need to see a verified complaint and I need, from the injured party, and I have to have an opportunity to face my accuser, as you mentioned at the beginning of this entire hearing. So who is the injured party? That's the question. Who's the injured party? Why am I here? I don't understand why I'm here.
You paid $440.32.
So this is very important what she says next.
You just have to count one and count two, and you should approve the claim. All right, sir, I'm gonna just exercise my discretion. I'm gonna dismiss count one and dismiss count two, and just order the fees you've already paid.
She said, I'm going to exercise my discretion, dismiss count 1, dismiss count 2, and just order the fees be paid. Now, the reason is because this, as it says right there in the caption, all crime is commercial. The entire system's commercial. It's based on a trust indenture, and they use the property held in trust to generate their own commercial paper. That's what traffic tickets, bonds, all that, court fines, coupons, all of it is commercial paper, the same as the Federal Reserve noted. Evidence is a debt, right? And they're able to sell that to institutional investors. They're negotiable instruments. You guys probably all well know that traffic tickets and other evidences of indebtedness are generally negotiable instruments, and they sell those to institutional investors. So she, even though she's dismissing the case, as soon as this charge was brought up and the securities created, the commercial paper created, they sold it. And now they're on the hook for it. So she's trying to get him to still pay for it, even though he's not being found guilty of anything. And listen to him. Good for him, too. Good on him. Watch.
To cover court costs, okay?
So,
No charges are pending against you. They've been dismissed. Interest of justice.
so I'm letting the record show that the defendant, Ryan Michael Thor, with case CMZ 606406, all charges are dismissed. Is that correct?
And whatever fees were paid are going towards court costs, okay?
Well, those fees are bail, and they should be returned after dismissal.
Okay, you know what? I don't have a problem with returning your fees. I don't.
Thank you.
All right,
Boom.
wait. All right, have a good day, Mr. Thor.
Thank you, ma'am. I appreciate your time.
You're very welcome.
He crushed it. So since we were talking about rights, okay, and we're talking about the difference between lawful and equitable rights, she presumed him to be in violation of the equitable rights of the security interest holder over his estate by not having, a license, permission to use the vehicle, quote unquote vehicle, commercial, right? And or not having a license plate. And so when he says I need to know who the victim is, right? That shows the difference. Are you enforcing a lawful right, or are you trying to enforce an equitable right? And if you're enforcing an equitable right, what contract do you presume me to be under? Right? Who have I harmed equitably, right? By not performing some obligation. How are you're trying to enforce terms of a trust? What trust do you presume me to be in? Because they can never let the cat out of the bag and tell you that the 14th Amendment citizenship is a trust office. They can't let the cat out of the bag, but that's exactly what it is. So if this is a court of law and you presume I've committed a crime, then I need to see the verified complaint, signed sworn affidavit from a living victim, right, with a witness. Otherwise, if this is a court of equity, right, then I need to see the contract. I need to see what trust you're presuming that I'm in order to try to enforce equitable rights upon me. And that's one way to challenge jurisdiction. It's or equitable rights violation upon me, rather, would be a better way to say that. But that's yeah, he crushed it. And that ties right into what we're talking about with rights right now. So lawful rights are derived from absolute ownership of property. This type of ownership has been termed allodial, right, or perfect title. And it means that which is free from any superior claim. That means there's no paying property taxes. There's no superior interest holder that can demand performance of any obligation of you for holding that property, whatever it is, whether it be land, automobile, doesn't matter, right? That's what allodial means. And that's your birthright as an American, as a Michiganian, as a North Carolinian, South Carolinian, Texan, whatever you may be. That's your birthright. And it's enshrined, like I said, in Wisconsin State Constitution, the very first one. All lands within the state are declared to be allodial, and feudal tenures are prohibited. Period. Okay. And the reason that lawful rights are enforced at common law is because the violation of someone's lawful right is a violation of the free will of another individual's living soul. And to truly understand the importance of this, we're going to have to look at this treatise called A Treatise on the American Law of Administration. Now, administrative law is not law, but administrative law can be immediately traced back to the original law, especially through the Magna Carta, which infected common law with the concept of Roman trust law in the first place. It's a double-edged sword. For people who know the law, it protects your liberties if you know how to stand on them, enforce them, and keep from falling into the trap of administration. But to the ignorant, the Magna Carta gives full carte blanche permission for administrative law to move forward and take you out of common law and into the private law of what they call in the Magna Carta, two lawful and discrete men of that fee, which today is the judge and the DA. Okay. So let's take a look at the American Law of Administration real quick. We're going to go to section 1 first. Let me share and you guys, this is a great book also. If you've never come across this treatise before, I highly recommend you read it. Let me see. I think it is right here. Okay. So we're going to go up down at section 12 right now. It's a great, great book. It covers pretty much everything that Blackstone covers to a certain degree. But the reason, so in order to write a law or write a treatise on administrative law, he has to start and trace administrative law back to the original law in order to give administrative law validity. Otherwise, as we read in Blackstone, it's of no force or effect, right? It's not valid. It's actually, if it's contradictory to the law and not in accordance with the law, then it's actually just invalid. And that's the Supreme Court justices knew this and say like Marbury versus Madison, where they say all laws repugnant to the Constitution are null and void. That's what that means, because the Constitution is written at common law. The constitutional rights enumerated in the Bill of Rights, which had to be amended to that infernal and subversive document 2 years later, are common law rights. Okay. So he says, and I'm going to zoom in for you guys. This is deep, and this is the foundation of all law right here. My property is that which is mine. That only is mine, which I acquire, hold, and dispose of by my will. It is my will which determines the acquisition of a thing by me, whether originally by reducing to possession and thus making my property that which was no one's property before, or by contract, by which a thing becomes mine through the concurrence of my will with that of its former owner. Okay. So he's saying either it doesn't belong to anybody and I will it to become mine, or I enter into a contract and my will is in accordance with the will of its former owner. We come to an agreement. We both receive consideration. It becomes my property. That's contract. So since I cannot rightfully acquire the property of another without his consent, that is, without his free will, it is obvious that the will of the original owner is a necessary element in my ownership and in the ownership of anyone who may lawfully acquire it after me, and remains operative until the property has lost its character as such by voluntary abandonment. So once something becomes property of someone, then there is constantly going to have to be an accordance of will between the seller and the buyer until that property is voluntarily abandoned. Then it's open for the taking by anyone. And that's the abandoned property law, is that common law, right? If you guys have seen Good Will Hunting, they talk about how smart he was. It says, yeah, you use some aspect of abandoned property law to get out of car theft, right? And you could theoretically see how that would be possible. It's kind of like a little Easter egg in that movie. So he says, by my own free will, I may abandon my property, whereupon it ceases to be such and relapses into the condition of res nullius, subject to become property by the sole will of any person who acquires it. Now, this is important right here. He says, I hold or use a thing which is mine at will. Okay, this book's from like 1826, by the way, and it has tons of court case citations at the beginning. So I hold or use a thing which is mine at will. Matter is unfree, i.e., it has no will. Now, that's so important. That's why they have to reduce you to property, because property is not considered to have will. That's also why they consider persons not of age, okay, incompetent, such as drunkards, spendthrifts, lunatics, etc., and paupers who cannot survive by the exercise of their own free will, to not have the capacity for free will. And as a result of that observation, they can be considered property, chattel. Chattel does not have free will. Chattel just means movable property, by the way, but slaves are chattel. Indentured servants are chattel. Okay, minors under guardianship are chattel. Children are chattel of their mother and father. All right, and that's what the state has done to you, is essentially turned you to property so that they don't need your consent to do certain things. They can act on your behalf using essentially power of attorney through their administration. So matter is unfree, i.e., it has no will. It does not belong to itself. Neither right nor duty can be predicated of a mere thing. Its quality is to offer resistance. It is therefore negative to my will. So this shows his deep, and a lot of jurists, including myself, have a deep understanding of the esoteric, like the what they would call occulted, hidden from plain sight, knowledge of the mechanics of the universe. Some people call it the Hermetic principles. Is a very good place to start if you've never become acquainted with it. It merely outlines and analyzes the fundamental operation of God's law of the creation. And what that is the interaction between polarities, positive and negative. Okay. It takes positive and negative to create life, to generate, to create energy. Positive and negative end of a battery have to touch to create a circuit. Man and woman have to come together to create a child, right? And this is universal from the macro to the micro. And so in business, the words commerce, let's start with this. The words commerce, congress, and intercourse all have the same meaning archetypally. The root meaning is exactly the same. It's an exchange or interplay between polarities. You can even throw war in there, but we're not going to get that deep. And so what he's saying is that the essential, the element of property ownership that is taking place is there is an exchange of positive and negative energy when he wills something to become his, right? When you will something to become yours, matter, its quality, its essential quality is to offer resistance. Okay. It's not, you have to bend it to your will. And in doing so, you exert the positive force of your will against the negative force of the thing you are making your property. And what happens is the positive and negative, just like a mother and father, come together and the thing becomes transformed in part of you, an extension of your will, the ultimate realization of your will, and the external sphere of your freedom. As he puts, that's why property ownership is so important and why all rights are derived from property. And the elite know this. That's why they still protect everything with houses. They got the House of Rothschilds, the House of Rockefeller, gefilte fish, the House of Rockefeller, the House of Morgan, so on and so forth. You got, anyways, we'll get into that. Maybe not this stream, but in one of the upcoming ones. So My will, in realizing itself, overcomes this resistance and subjects the thing to its purposes, changing its form, destroying, consuming it. That which is mine is thus part of my personality, of me, insofar as its end and purpose of existence is the satisfaction and realization of my will, and to serve it for its purposes, his will, as my bodily limbs serve me. So right here, and in fine, will then is the essence of property and law. Free will is the essence of property and law. Have you guys never found it curious that they always have to show you what they're going to do before they do it? How they have to manufacture consent. They have to get that consent. They have to give full disclosure. They have to show you, because of that essential element of law, the one and only law, not written by them or us, written by or created by God, is free will. Do not violate the free will of one who is found to have free will. So they got around that by making you chattel property without free will. And how'd they do that? They offered you benefits, all you EBT people. I wish you guys would wake up. It's a trick. It's a trap. Yes, I know how it's funded. Okay, we're going to get into that. But it's actually funded not by taxes per se directly. What it's funded by is the indenture of all 14th Amendment citizens to a membership corporation, where all property and labor is controlled by the corporation, and they can take from one to give to another as they see fit. So they mortgaged your estates to a central banking cartel in order to appropriate money from the central banking cartel for your benefit. And of course, to be able to do that, they had to create beneficial programs such as welfare, Medicaid, so on and so forth. Okay, that's the trap. Never, there's no such thing as a free lunch. So, yeah, like say what says, what the gov gives, the gov takes. And Janusz says that's why there's so much predictive programming. We've warned you and we've told you, and you did not react to it. So that means you've accepted. That's exactly right. Consent. So will then is the essence of property. Without it, there is none. Hence, that from which I have withdrawn my will, I have abandoned, ceases to be my property, and becomes, as we have seen, res nullius, the appropriation of which by another is no violation of my right, because it's in no collision with my will. And that's why that's why there's an entire body under common law called abandoned property laws. It determines what conditions something is, and that's what I mean, man writes about the law. Okay, so this fundamental thing, we didn't create this, that like when you can't violate someone's free will when they acquire property. But what they did do is they say, okay, we're going to set these guidelines on when something can be determined abandoned. That's as far as man's creative legislation can go. That's it when it comes to the law, unless it's administrative law or something like that. So go down here to this section. No, go down to section 4. This is very good. So he says, property then is the realization of the free will of a person, the external sphere of his freedom. As such, it partakes of and is clothed with the dignity and inviolability of the person. So what does it mean when somebody else tells you how to use your property? Well, they've stolen your free will. You have no free will, right? At all. So yeah, sure, you can have that automobile, but you got to register it to us, which means you give it to the state. They put their name on the back of it and their account numbers on the back of it, right? And then they tell you how to use it, because that automobile, you have no right to property. You're under a trust indenture because your rights to property have been mortgaged to the central banking cartel. Therefore, any property you acquire must be placed in trust via registration to be used as collateral for the public debt, and allow the Federal Reserve System, which these courts are all a part of, to generate revenue from the property while the debt is outstanding. And that's what traffic tickets are. And the entire motor vehicle code is just a form of revenue code. It's a way for them to generate revenue. They even tell you that's what police are doing when they're issuing traffic tickets. And the word revenue, revenue, right? Putting you into another venue. Not going to get into that right now, but anyways, yeah, that's what's taking place. So they've stolen your free will. And like you said, and it goes back to the spiritual realm, because it is basically the prostitution of the gift God entrusted you with, which is your free will. They have now prostituted it. to the central banking system. It is satanic to the highest level. It's insanely satanic. Okay, eyes wide shut type stuff. So anyways, the things that which constitute property can have no rights, for they have no will. Now look at the way he writes this, right? And will alone, or the person in which it has its abode and vehicle. That's so important because that's essentially what God entrusted you with. Above all else, it's your soul and free will. Okay? It's what the devil's so jealous of, allegedly, right? And notice how he looks at how he states that. It's not the person at all. It is the free will which law is addressing, the free will of that soul, something that's intangible, something that can't even really be put into words, where it comes from, how does it operate, right? That ultimate esoteric thing, the free will, and what you believe is your personality is actually just the aggregation of the experience of your free will. What do I mean? So it's a set of beliefs and habits that you built up over time according to your experiences to either spare you pain or bring you pleasure. And it's ever transient and shifting as like quicksand based on your everyday experiences. Yesterday you liked this, today you had a bad experience with it, you develop a new belief and a new habit to avoid it. It's always changing. But all of those things are illusory and they're not actually what you are. You are the silent observer in the seat of consciousness. The same you that stared at you in the mirror when you were 8 years old brushing your teeth is the same you that's looking at you now. It's just the body's different. Okay? If this were not the case, then when you have a thought or you have a song playing in your head or something like that, if your mind is the one thinking the thought, then what is it in your mind that hears it? And that's what I'm talking about. And the essential quality of that thing, that spark of divinity inside of you, is the free will. And it uses your person as its abode and vehicle. And everything that externalizes in your life and around you is a direct result of this free will. It is the ultimate expression of your free will. And therefore it's sacred and it belongs to you, and they've stolen it from you. They've stolen it from you. J. Batista, this is called a treatise on the American law of administration from, I believe, 1823. I could look at the date after I'm done reading it, because you got to go all the way up through the court cases and everything. It's like a fifth of the book. But 1823, and it's by J.G. Warner. Warner spelled Woerner. You can find this on archive.org. Well, the government took control of archive.org, so hopefully you can still find this on archive.org. If not, just comment or something. I've got the PDF saved on my SD card in a mega folder for the Jurist Society. And I definitely don't withhold things like this from anybody. So if you're interested in reading it and you can't find it, just let me know. All right. And will alone, or the person in which it has its abode and vehicle, can be the subject of a right and of its correlative duty, right? The law recognizes and deals with property only insofar as it recognizes and deals with the will of the owner, realized or externalized therein. That's important. He's saying, like, property cannot be seized of a right, meaning it cannot have a right. Okay. The common law way to say that is seized of a right. Property cannot be seized of a right because it has no will, and it cannot carry out the obligations associated with that right. Okay. Because rights always come with duties. Just like the common law rights we had, the duty was to remain independent and take care of yourself. I'll prove this. We can go to Pennsylvania's original constitution in the Avalon Project. It's from 1776, September 28th. You go down to section 26, okay, for the plan or frame of government. 36, sorry, not 26. Go down to section 36, and it tells you right here. And this is the duty that comes with the rights that you have as a sovereign. This is the duty to remain independent and manage your affairs, to violate no one else's free will, and honor your word. It says in section 36, let's see if I can zoom in a little bit for you guys. Okay. Section 36. As every free man to preserve his independence, if without sufficient estate. Estate is your interest in all property. Essentially, a substantive definition of estate is your property, your personality, your labor, and your property. But ultimately, what an estate is it's an interest in property. Okay. The choice of which is determined by the free will, your free will and your personality, and also how you choose to acquire it is the labor. So I include those things. But what he means is, as a free man to preserve his independence without a sufficient estate, meaning if you can't just live off your interests in property, okay, and like the wealthy do. He says they ought to have some profession, calling, trade, or farm whereby he may honestly subsist. There can be no necessity for, nor use in establishing offices of profit. Offices of profit, and they're very hard to find a definition of it, but I'll tell you what it is because I've done quite a bit of research into it. Offices of profit are welfare offices where private persons are appointed to take administrative control of some area of public concern. That's what all these administrative agencies are. They're quasi-governmental, but they're not really governmental. They're private corporations exercising governmental power. And they're essentially exercising, if you really want to think about offices of profit. And so he's saying, as long as everybody can remain independent and subsist on their own, we have no use in establishing these offices of profit and setting up poor laws and settlement certificates and all that stuff, you know, that they inherited, that became part of the body of law from England. Okay, that we inherited, grandfathered in here, because Michigan started issuing settlement certificates to all its immigrants and paupers, and pretty much everybody made it just like it was standard. They were all the way in on this plot to enslave everybody since the beginning. I'll never cut Michigan any slack for that because they absolutely were. And I can read it in their laws. The fact they established a probate court before they were even a state, 1826, right? So anyways, he says, so there can be no use in establishing offices of profit, the usual effects of which, and this is the context that gives you an idea of what I'm talking about, the usual effects of which are dependence and servility, unbecoming freemen in the possessors and expectants, right? Faction, contention, corruption, and disorder among the people. That's what he's talking about. So the people who are expectants of the benefits and the holders of the benefits, it causes them, by operation of law, to become dependent and servile upon that office. Like generally, it's called overseers of the poor. And of course, the people who run the office, they get to take an administrative fee out of all the estates that they administer. And so, like he says, faction, contention, corruption, and disorder among the people who are running the office, right? Very, very wise statement here. By the way, we'll take a look at how dependency causes you to lose your lawful rights. Let's go back to Blackstone's commentaries, and then we'll hop back to J.G. Warner. Actually, let's finish this J.G. Warner real quick because I'm almost done with what he has to say for now. Says, so the law recognizes and deals with property only so far as it recognizes and deals with the will of the owner, realized or externalized therein. And this is the most important. So any atheist who studies law is going to go nowhere for this reason, like J.G. Warner says here. He says, for the sphere of the law is the spiritual. It operates upon and through the will alone. Thus, the law recognizes in the property of a deceased person his free will, that is his rational will, and enforces it. And that's the wedge that they're able to get in and take administration. If somebody dies without a will, then automatically the court gets to appoint an administrator and appoint his own people to carry out what the court believes the will of the person would have been. And this is supposed to be done according to equitable maxims and principles. So, but obviously, you know that it's not. All right. So we're going to hop over to Blackstone. How does dependency? So that's one way you can come under administration. Say you're an heir and your mother and father, something happens and you're not of age and there's no family member around to be able to take executive control of the estate till you come of age, then the court automatically appoints a guardian and takes administration of the administrative control of the estate. And that's what the priests were doing to the barons, right? To cause the Magna Carta to be written in the first place. Is they were, you know, the barons would be off at war, something like that, die, and then the priest would just, like vultures, just capitalize, because that's what William the Conqueror did. He split the courts and gave the spiritual matters, called ecclesiastical matters, to the priests, whereas the common law courts that they had dealt with both spiritual and temporal matters, and they were self-governing, okay, in what was called 100 courts. But we might not get to that today. I'll pick up wherever I leave off on the next stream. But yeah, so anyways, and they would essentially take administrative control of the estate and just pillage it and screw the heir out of his inheritance. All right, let's go to Blackstone. Blackstone's commentary, book 1. We are going to go to page, let's see. Actually, I didn't write this one down, but I do pretty much remember right here. 45. Man considered as a creature, meaning you're created, okay? Man considered as a creature must necessarily be subject to the laws of his creator, for he is entirely a dependent being, meaning you can't exist without God. So you have to subject yourself to the will of God, follow his law, right? You have no choice, okay? So he further says, a being independent of any other, meaning outside of God, because no one has a choice about that, but a being independent of any other has no rule to pursue, but such as he prescribes to himself, okay? And that's the responsibility, it's the duty of sovereignty to stay in that state and be beholden only to God and subject only to God. It says, but a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends as the rule of his conduct. Not indeed in every particular, but in all those points wherein his dependence consists. Well, guess what? 14th Amendment citizens owe their entire existence to the federal corporation because it is a trust office and a creature of the federal corporation. Right? This, by operation of law, happens when you become a charge to the state. It's called becoming a charge to the state or a charge to the township. And that means you go and ask for benefits, for food, for shelter, for something because you cannot survive on your own. And as a result, you're considered to not be able to properly exercise your free will in a responsible manner. So you're presumed to not have one and you become property. And just like we're all dependent on God and have to conform to his will, these overseers of the poor, everyone's a pauper now because you have no access to lawful money. That's one of the layers it's one of the snares they've placed to pull you into administrative law. It's why they got rid of lawful money, because now you have by definition, you can have 1 million Federal Reserve notes in your bank account. You're still a pauper. Why? Because you have no access to real money. You have no access to lawful money, which is gold and silver. You can go buy it as a commodity because they've screwed the whole system up now. And instead of gold and silver being money, they're now commodities you can invest in, which is absolutely asinine. The word dollar means silver. A dollar is an ounce of Spanish silver. That's what it is. And I talked about that last time on the stream, while they're removing the artificial deflation they've had on the silver. So nobody became suspicious about the fiat currency system, and everybody just participates in this economic system, even economists, and they have no idea how money works or economics or law. And it's insane. It's insane. I want to pull my hair out sometimes when I hear these people. You spent how long at business school and you don't know your ass from a hole in the ground? What are you talking about right now? Okay. Anyways, that's one of the things, a lot of people have a large capacity to learn this, and that's why I do it, because all of you pick this up very well, especially the members of the Jurist Society are incredibly, exceptionally intelligent people. Anyways, this is the principle behind settlements and behind poor laws, and one of the ways that you can come under administration. It's an excellent book, by the way. I highly suggest you read it. Sergeant Frog Dog says that's why when you buy something like a car, you make sure you put the bill of sale, whatever fiat amount, plus 20 and silver. I personally use gold. Yeah, that's right. Sergeant Frog Dog has MCO to his automobile and everything. So, but you have to actually, that's the whole thing. There's a difference between buy, sell, and purchase. There actually is. See, the Securities and Exchange Act of 1934, changed that and use statutory construction to make purchase and exchange and trade all mean buy and sell. But that's not the case at law. So to buy something is with lawful money, gold or silver. You buy it. Okay. Exchanging or bartering is when you give something of value to receive something of value, right? Like a cow for a horse or something, right? Just an example. Purchasing is an exchange of negotiable instruments. Okay. Now, the interesting thing about that is negotiable instruments always have conditions attached to them because negotiable instruments are unrealized obligations. They're not inherently valuable. The only value of a negotiable instrument is the promise of the performance of a future obligation. That's it. Whether it be pay something, do something, whatever that has a monetary value, but inherently it's not valuable. And so whatever you purchase with a negotiable instrument, say like a Federal Reserve note, you're placing all the liens, all the obligations that come with that instrument required for it to be valuable onto the property you're purchasing. And in this case, it's your sweat equity. Okay, it's your promise to pay traffic tickets and all the other stuff and adhere to the trust indenture. And because of that, and because you use Federal Reserve notes to buy your automobile, the conditions that are tied to those Federal Reserve notes require that you go and register it and obtain a license to use it and et cetera, et cetera. So it's very important. That's a very good point. Frog Dog, absolutely good point. So what is paying a stripper for a lap dance? I don't know really what that question means. I guess a good time for some. I don't know. Probably adding to the hatred of men for the stripper. Not really sure. So anyway, let's get back into this. What time is it? 7:36. Yeah, I can go for a little bit longer. And I will. I'm not going to be able to get to everything tonight, but I will pick up on this next stream. If you guys, in the comments, if you let me know what you think, and if you're interested in learning more about this and the resource or, the authoritative sources where I get everything, because everything I tell you, I will prove it. And not only will I prove it, but I'll give you the authoritative sources. Treaties at law, like that American Law of Administration, a treatise on the American Law of Administration, Blackstone's commentaries, right? Elementary Law, Smith, all these treaties, they're admissible evidence in court. The issue is you don't want to be fighting in a court of equity. What you want to be doing is challenging jurisdiction and never consenting to the court of equity. Because in order for you to end up in a court of equity, you have to be under some sort of trust indenture or a party to some sort of contract. Equity only deals with the things that law cannot. That's why it's not law. And that's why the judge can use his sole discretion and act like a god in the court of equity, because he's supposed to be adjudicating creatures of the minds of men, such as corporations, trusts, etc. Okay, in equity. Or implied or express contracts. They can also deal with that, but common law can also deal with that as well. However, if you're trying to seek an injunction, like say to stop somebody from doing something in the future, law can't do that, because law can only deal with what exists in fact, what is and what has happened to what is, right? That's it. That's all that the law can deal with, and for good reason, because when you start getting into the realm of fiction, well, now we're discussion about AI pre-crime policing. It's insane. It's absolutely insane. But anyway, so equity deals with fiction. So it can do an injunction and deal with the future. You can only have a DUI in equity. You can only have a DUI in equity. You can only punish somebody for what they might have done as if they did it, like saying harm someone. Because remember, in order for there to be a crime, there has to be an injury. There has to be a harm done to another living soul. But DUI punishes you as if you did harm someone, right? And that can only happen in equity. That's one of the ways that you're in equity. And equity is primarily for the adjudication of trusts, for the enforcement of the terms of trusts, indentures. And that's why all these courts are courts of equity. Trusts can only be adjudicated in equity because trusts are entirely a fiction. The legal fiction, the straw man that everyone talks about, it's simple. It's the trust office of the 14th Amendment citizen. The IRS manual literally calls the Social Security number holding 14th Amendment citizen an enfranchisement. And the franchise is subject to the merchant law. There's a guy that did a great little speech on that. I posted on Facebook as a reel earlier today. If you guys haven't watched it, definitely check it out. He's right. It's in franchise. You're an enfranchisement of a insolvent corporation, right? An insolvent, bankrupted multiple times corporation. So, anyways, yeah, that section 4, the sphere of the law is entirely the spiritual. And I'll get more into law and equity probably on the next stream. Again, I always do. And so I have many streams that delineate the difference between law and equity and the importance of knowing it, because you can walk into the court and just say, hey, is this a court of law or court of equity? Oh, it's a court of law. Okay, it's a court of law. Then where is my verified complaint? If you're enforcing the lawful rights of another, that means I must have injured them if this is a court of law, right? And so now I have a right to face my accuser. Literally, one of the jurists this was in a court case about a year ago, and he did an at-law counterclaim, and he did a great job. He was just brand new. Now he would tear it up, but he actually caused the judge to have to ask him to adjourn, right? And then he remembered he was the judge and goes, oh, no, wait, I'm adjourning this. Because he didn't know what to do. He was actually getting called out on his BS at law with an at law declaration. But anyways, the clerk tried to tell him the state is the victim. Well, imagine this, okay? The state is the victim. How can the state be a victim? And how did I victimize the state? So say I'm driving without a license plate on my automobile because I have the MCO, okay? I'm driving, and some road pirate tries to pull me over and tells me, you're supposed to have, all residents of the state of Michigan are supposed to have registration and a license plate when operating their vehicle. Well, he doesn't realize it, but he's trying to establish jurisdiction with the words he's using, because the word jurisdiction, juris means law, diction, as in dictionary, means to speak, to say, to words. It's words. So jurisdiction is law speak or law words. And the words that you use determine the jurisdiction that you're under. And so he's saying resident, which is a resident alien, a foreigner, right? He's saying operating, right? He's saying registering. Whatever you register, you give the controlling interest over to whomever you're registering it with. That's just a fact. That's how William the Conqueror got all the allodial titles from the English when he invaded, and they voluntarily surrendered it for security because the Denmark had just invaded them. And that's why Ben Franklin says those who sacrifice liberty for security deserve neither and will lose both. They used the same plan, wash, rinse, repeat. They refined it in England over the course of about, say, 700 years, and they got it down to such a science that it only took them about 100 years to do it here once we became sovereign. So, all right, we'll get into the difference between law and equity here a little bit. It says, let's see. Equitable rights, as I previously stated. So we get that the absolute lawful rights are, they're derived from absolute ownership of property. Equitable rights, which should be more aptly termed privileges for the purposes that they arise from shared interest among two or more persons in the same property. What does that mean? It means two or more individuals have an interest in the same piece of property, right? And that generally results from what is called in these treaties you'll read, it's called privity. Privity is essentially confidence reposed, okay? So it results from privity or confidence by the owner of or the superior interest holder to. So they don't even have to have that absolute ownership interest to convey a portion of their interest to somebody in trust. They just have to hold the superior interest to the party that they're bringing into the trust. Well, they do thereby creating the trust, hold the superior interest in the property. Okay. And, the person who's coming to become part of the trust, the trustee, is seeking to have the equitable right of use, which is really a privilege, and it's called usufruct. It's usury of property. So let me give you an example. If I say you need a car to use and you have no car, and I have extra cars, Okay. And so you come to me and say, hey man, I'd really like to use one of your cars to get on my feet. And I go, okay, well, let's draw it up in a contract. That contract becomes a trust instrument. What I do is I lay out the terms of use and the conditions under which you should use my property. And that's the trust instrument. Okay. And I'm considered the beneficial proprietor because I'm going to receive a benefit from this. Part of the terms are, hey, you have to pay me a monthly rent, okay, of whatever amount of money. Then whatever money you make with it, you have to give me, say, 10% of the profits you make with my car. Okay. Now I can add extra provisions. I can say, you can't take this car out after 7 p.m. and you can't leave the house before 6 a.m. in the morning. Okay. So now you have to be home by 7, take it out by 6. I mean, you can walk around after 7, but you can't use my car. All right. And you're like, okay, cool. That sounds fair. And you sign it and you become the trustee of this trust. Okay. And I am the beneficial proprietor. So in order to enforce my rights or yours, law is not cognizant of this situation because nothing in this trust indenture that we've created is law. It's private law, as I said, or Jus Particulare, which is private law. It's private law. And so therefore the common law cannot actually even look at it. So that's what equity was created for. It used to be called chancery, and how it got put into such widespread use was to compel a trustee to answer under oath the allegations of the set decay trust, the living trust. That's what a subpoena was created for. I've shown you guys that before. That's in the practical treatise on the law of trusts from the 1800s, and he says that, as well as the parents of the trust were fear and fraud, because it's to remove personal liability. That's what it's all about. So now say you have it out after 7, right? Now I want to charge you for violating the terms of the trust indenture, but I can't take you to a court of law. We have to go to equity, right? So I subpoena you into a court of equity. And now because it's dealing with fictional matters in a realm of fiction, not law, the judge is the ultimate tribunal, and he decides the outcome of our dispute arising from the trust. He has absolute tribunal authority. He's basically God up there. And that's why they wanted to reduce everyone to trustees of their own property, right? Trustees and chattel property of their own estates in order to be able to act. The Bar Association can now play God, can make laws and enforce law, or really make rules and regulations and enforce them under the color of law. Right? Put you in jail. You didn't even hurt anybody. Say you're driving without permission. You don't have a license. I've seen people do a year in jail for driving without a license. You took away somebody's freedom for them not paying you for permission to use their own property. And that's what I was getting to with the thing. Say the road pirate pulls me over. I don't have a plate because I have my MCO, which is the allodial title. Now, if he somehow creates an attachment, because I'm not going to give him an account number, but say somehow he's able to create an attachment, and then generate the commercial paper, the ticket, and you get summoned as an apparition because they consider you to be dead to the law because you're locked in a trust indenture, bankrupt, you're in a legal underworld, right, with no lawful rights to anything, so no access to common law, because you need lawful rights to have access to common law, which requires absolute ownership. And you don't even own your own body. They do. You're chattel property. You're just using it. So you're the usufruct, basically. So anyways, if the clerk in the court were to say to me, the state is the victim, when I say, where's the victim? I need to see a verified complaint. The state's the victim. The following question I would have would be, well, how did I victimize the state? By not conveying the right of my property to be placed in a trust and used as collateral for the debt of a foreign corporation, a foreign principal. Is that how I victimize the state? Because it sounds a lot more like the state's trying to victimize me. That'll shut them right down. Sounds a lot more like the state's trying to victimize me. And I can prove everything I say. So I come into court with a lot of documents. A lot of this stuff that I show you guys. You wanted to print this, you wanted to print this page out. You just look for the print page when you're scrolling through in your browser, and then, do Control P, and then just select that page and print just that page. Hey, I've got this excerpt from a treatise on the American law of administration where it delineates what property ownership actually is. And you know what I mean? This is what you guys are trying to do. You're trying to administer my estate unlawfully and shut them down. Shut them down. So there's a huge difference between law and equity. And one of the most important things that you can know is that distinction between law and equity. The Constitution itself distinguishes between law and equity. I'll show you. This was actually what I came across that first tipped me off to it years ago. Let's see, Article 3, Section 2. So it says right here, and clause in Section 2 says the judicial power shall extend to all cases in law and equity. Well, if equity was law, it wouldn't make the distinction. They wouldn't make a distinction. It said law and equity. That's because law is the law. As I've spent the last 2 hours explaining, there's only one law. That's it. But equity is private law. So, and that actually ultimately comes under the church. So when I was doing research for, when I was doing research into the port districts, I was explaining to you guys earlier how they brought special maritime admiralty, or it's not admiralty because that's the military side of it. It was special maritime territorial jurisdiction inland by creating port districts within the state for international commerce. And that's all in preparation to sign us on to the UNCLOS treaty with the United Nations, which hands all of that over, all those territorial waters over to the United Nations. And that was their plan. And recently it's been kind of flustered. In fact, there's been several okay people, I guess, because they haven't signed on to the UNCLOS treaty because they said it would undermine our national sovereignty. They're absolutely right. I'm not saying they care about the common people, but they just obviously are wealthy people who don't want to submit to even more wealthy people. So whatever, it's just rich people fighting rich people. But anyways, this is interesting. It's called the Ecclesiastical Law, Volume 1. And I was surprised when I came across it because, look, I actually came across this because one of the jurists, Jeff, he sent me a document where this guy cites a bunch of case law. And he talks about everything that I talk about the 14th Amendment. And then he has even some extra stuff I had not seen, like this. And this tells you of American canon law or of the national canon law of the United States. What is meant by American canon law? By the national ecclesiastical law of this country, we understand the various derogations from the Jus Commune, right? Which means we're common law. See, and he doesn't even want to say what Jus Commune is, and that's why I looked it up. It's common law. I did the Google Translate. Or the different customs that exist among the churches. So he's saying that by the national ecclesiastical law of this country, we understand the various derogations. Well, I had to look up derogation. Okay, derogation is the partial repeal of a law, usually by the subsequent act that in some way diminishes its original intent or scope, right? That the partial abrogation of a law. To derogate from a law is to enact something which is contrary to it. So the canon law is contrary to common law, okay? And it says that we understand the various derogations from the common law, or it's, and you know what I mean? He's talking about two different things. It's saying it's either derogations from the common law, and I'll show you why in just a second, or the different customs that exist among the churches in the United States and are sanctioned or tolerated by the Roman pontiff. Yeah, sanctioned or tolerated. We say are sanctioned or tolerated by the Roman pontiff, for as was seen, no national law can become legitimate except by at least tacit or legal consent of the Pope. Again, the Jus Particulare, or private law of a nation, always remains subject to the authority of the Holy See. This is why the United States has always been an English company. Because in order to give our republic international validity, since all the princes of Europe are under the Pope, all of the international powers are under the Pope, ultimately, right, especially of Europe, the people we'd be primarily doing business with, then we had to have at least tacit consent from the Pope to become a nation. And so this was part of the agreement. In fact, if you read the Treaty of Paris, the way that this should make more sense now, Treaty of Paris, when they introduced King George, get out of here. When they introduced King George like this, most potent Prince George III, by the grace of God, King of Great Britain. So he's a prince on the world stage, but in Britain, he's a king. France and Ireland, defender of the faith, Duke of Brunswick and Lunenburg. And then right here, Arch Treasurer and Prince Elector of the Holy Roman Empire, etc., and of the United States of America. And this is how they had to do it to give our republic international validity through the Pope, because that's how this has worked since like 800 AD. It literally has worked this way since 800 AD. And that's why these kings claim divine right to rule and all that stuff, because they're sanctioned by the Pope, who claims to be the vicar of Christ. And he's the one they're the one undermining our sovereignty. And they have been. In fact, I'll show you when they said the derogations of the Jus Commune, or the common law, he's talking about the Bar Association, who's responsible for doing that. They're merchant attorneys. They can only operate in feudal systems. Okay, feudal means the government controls, like say the king or whatever the governing authority is, controls all the labor and all the property, all the land of the nation. And I don't know if I'm going to have time to get into that tonight. I might want to, because that's very important to understanding what the 14th Amendment is. This is a neo-feudal society that we live in right now. It's neo-feudal. So this right here, let's go back to this ecclesiastical law. So what they're telling you that the private law of a nation, meaning the statutes, the statutory law of a nation. They can say, it almost seems by this that they consider the government a church, which would make sense because the earliest governments were the priests of the temples, and they were also the first bankers, right? So the priests of, like, say, the temple of Aphrodite or something, or the temple of whoever, right? What was Vestigal virgins, or anyways, the priests would mint their currency with the face of whatever god or goddess they were the priest of, and then they would operate as a banker, and they also operated as the lawmakers. And so this system is very old. This is what the Tower of Babel was, and they're trying to erect a permanent Tower of Babel with the digitalized ID and AI governance. But I'm jumping way ahead because we're still way back here in the history of this stuff. So they're subject to the authority. It says the private law of a nation, Jus Particulare of a nation, always remains subject to the authority of the Holy See. And you got to think about that. The Maritime Admiralty, sea means sea. He governs the seas, which is international is considered to be sea. International business is the sea of commerce, which ultimately comes under the Pope, as they're telling you right here. This thing was sanctioned by archbishops. They're all listed in the beginning. This is like the 9th edition of this book. This is an authoritative treatise, okay? And they're telling you. And it says that the Holy See can repeal it. It says in such a manner as to be repealable at any time by it. Hence the Jus National, or the exceptional ecclesiastical laws present in the United States, may be abolished at any time by the sovereign pontiff. So what I'm going to leave you guys with today is this. The Bar Association, which we all know is the greatest enemy of mankind, or at least you should know that if you do not know that, okay? The Bar Association was created by the Inns of Court. Inns of Court, which include Lincoln's Inn, Gray's Inn, the Middle Temple, and the Inner Temple. Okay, those are the ones that are left today. The Inns of Court are unincorporated secret societies that essentially study law. They were originally created to study and preserve the common law, but as we can see, they obviously have favored Roman civil law much more. And the entire history of law in the Western world for the past 1,000 years has been a battle between the common law created by God and Roman civil law, which is national trust indentures created by man, trying to become God and make law. So the entire history boils down to those two things. And the Inns of Court were originally created when they almost successfully put common law in disuse because they can never destroy it. But what they can do is bury it and bar your access to it by locking you in a national trust. And trust can only be adjudicated in equity. So if you have no lawful right to any of your property, including your own body, then you have no access to common law for any injury. You only have equitable rights to everything that can only be adjudicated in equity. And that's how they do it. That's a simple way of putting it, and I hope you understand what I'm saying. So the Inns of Court are especially the Middle Temple and the Inner Temple are located in the Old Templar Church in London, the Sovereign District of London. London, or Londinium, was created in 43 AD by Rome and has always been under the control of Rome to this very day, under the control of the Vatican. Well, it wasn't the Vatican then, but it wasn't necessarily the papacy at that point either, but it was Rome, and then it became the papacy, and then it became the Holy Roman Empire in like the 800s. But either way, they've always controlled England or London, and that section of London is sovereign. It's in the Magna Carta. It's in the Magna Carta where it states that it shall remain sovereignty and enjoy its ancient rights and liberties and etc. Right? And this is where all the companies that ended up becoming the national governments came out of, as I explained last time in my stream. At least I think it did. But without getting into that too much, the Inns of Court, let's look at this. Watch. I'll show you. It's better to just show you. Webster's 1828 dictionary. This is what was used for common law before Bouvier wrote his dictionary, because common law is supposed to be written in a language that everyone understands. And it was, even though it's hard for you to understand now, it's because people were much more intelligent and well-read and well-versed in the law back then, that the common person could understand the common law, right? So here we go. We're going to look up this word. So they're in the old Templar building, right? So Templar, let's look up Templar. Noun. A house near Thames, which originally belonged to the Knights Templars. The latter took their denomination from an apartment in the Pace Baldwin II, blah, blah, blah. Look at the very first definition. A student of the law. That's a Templar. Okay? Now, we also know that the Templars are knights. Now, what are bar attorneys? They are esquires. Whoops. Must have misspelled that. Esquire. Okay. Esquire. Boom. A shield bearer or armor bearer, scutifier, an attendant on a knight. So the Inns of Court are in the old Templar buildings, and they're sending their esquires out all over the world to do the bidding of the papacy and realize the papal bull Unum Sanctum, which is the one world trust. So the very first step was working in tandem with the central banking cartel to bankrupt. First, all these companies had to go out, settle, and become governments over large swaths of the world, right? So the East India Trading Company became the United States, the Hudson Bay Company became Canada, so on and so forth, right? Then these companies, the next thing was to get a central bank established, which they tried to do as soon as we became a nation, and then they tried to do it again, and that lasted until Andrew Jackson became president and kicked them out, and then they had their tail between their legs until after the Civil War and the 14th Amendment in 1913, they finally got a Federal Reserve in. And now we see that this was the plan the whole time, is because now the company, the Bar Association creates a legislative framework for the bank to be established and for the bank's currency to become the national legal tender. And then the government, the company that is the government, the corporate state, then balloons the debt up. And see, the problem that they had and why it was only finally successful in 1913 is that the company is supposed to have all of the citizenry under its umbrella as enfranchisements. right? As enfranchisement. So it's sort of like how McDonald's has all of its enfranchisements. If the headquarters of McDonald's goes bankrupt, all of the enfranchisements are liable for the debt of the principal. Okay. Well, same thing. But here in the States, the way the original government was set up is the people were protected from the federal corporation, which had the power to create the currency, right? But did not have any jurisdiction over the people within the states. So that's why the 14th Amendment was necessary. Once they got the 14th Amendment, which created the federal citizen and brought everyone under the umbrella, eventually by 33 it did, because it's still voluntary, but brought them under the umbrella of the federal corporation. Then the federal corporation could pop the debt balloon. Boof. Switch the currency over to debt. Okay. And then mortgage the estates of everyone who's become enfranchised under it and liable for the debt of the principal, mortgage their estates to place them in a perpetual trust indenture, where now the Bar Association can just create administrative rules and regulations regulating the use of property held in trust as collateral and essentially become gods on earth. And now once you've got these national trust indentures created, now they're at the stage of merging them into a one world trust. And this is all the realization of the papal bull Unum Sanctum from 1302, I believe it was, right? That's what's taking place here. So, last thing I'm going to show you guys. We're looking at this, how they said that, the canon law and the Jus Particulare, the private law, all comes under the Holy See. Well, guess what these bar pirates are governed by, and they're the judges particularly. Okay, check this out. Where is it at here? Michigan Code of Judicial Conduct. Canon 1. Canon 2. It's canon law. That's why they're dressed in black robes. They're still the priest class. Priest class have always had the control of administrative law because the word minister is right in it, and it deals with the spiritual aspect of death, inheritance, and managing estates. It's supposed to be charitable, right? The administration is supposed to be considered a duty to God and man, but they invert it and use it to their advantage by taking under administration people who could survive on their own, just by putting them in this situation that we find ourselves here today, without access to lawful money and under layers and layers of contracts like Social Security, etc. Right? So, canon law. So with that, I'll pick up where I'm leaving off today to get into what happened in England with the feudalism and how William the Conqueror, because that's in Blackstone's commentaries and everything. If you guys would like, let me know in the comments how you guys enjoyed this presentation, this stream. I'll take let's see, we'll look at some comments real quick. So FE Nation, email me. You're talking about your brother's case. Email me the details of that, man. I would appreciate that. Thank you. And then here I am. Pat says Judgment Day is going to be so sweet. Yes, it will. And Danny Blanco says bar pirates or judges are administrators and trustees. They make us the trustees without our knowledge. Exactly. That's what I've just been explaining. Except for when you realize how they do it, it's all through the 14th Amendment citizenship, which once again, I'll reiterate, is a trust office from its inception because it offers privileges, immunities, benefits, and protection in exchange for your autonomy, right? You're giving over administrative control of your estate. And when you look at who the 14th Amendment was made for, it makes perfect sense. It was made for the newly freed slaves who, because of their former state of dependence and servility, were unable to be independent, as we've seen in the Pennsylvania Constitution, which is required to be a free man and preserve your independence to be able to survive on your own. So the United States Corporation capitalized on this and created a new subclass of citizen, which is actually a trust office that they could then later mortgage for to be held in trust as the surety for the public debt. And that's why you have this fourth provision here. Watch this. So you got here, it's like, oh, all persons. First of all, these are not people. It says all persons, which are not people, born or naturalized in the United States and subject. So it's making you a subject to this English company, to the jurisdiction thereof. And that's why the Michigan Motor Vehicle Code, the definition of resident, says that you reside in this state, but establish that you're legally present in the United States, meaning you have made yourself subject to the jurisdiction of this foreign corporation. And it tells not that no state shall make or enforce any law that shall abridge the privileges or immunities of citizens. So, okay, so equal protection for people who, who are not able to exercise common law rights because of their state of dependence. Okay, well, we go down, and not only does this, the second section completely reform the government, which shows you that this amendment, the purpose of this amendment was to entirely reform the type of government we have into a democracy. But the fourth section actually shows the true intention behind this. It says the validity of the public debt of the United States authorized by law, including debts incurred for the payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. What? Wait a minute. Okay, so you're offering me these privileges, immunities, benefits, and protection in exchange for you having administrative control of my property rights and my property. And then also, I can't question what you do with them? I can't question the debt? What? So I did want to get to the welfare thing a little bit. And actually, this leads me right into it. And then I'll shut this down. But I was looking for this story I had read a long time ago, and I found it. And it's about Davy Crockett, which was a congressman we had in the early years of this republic. And it says not only is tax paid government dictated welfare opposite to any Christian charity, it also flies directly in the face of the Constitution of the United States. Hero of the Alamo, Davy Crockett was a colonel in the Tennessee Regulars and was elected to the House of Representatives from his native state. That was before his part in the valiant defense of the famed Alamo. He served 3 terms as congressman. While Crockett was in Congress, a distinguished naval officer died, leaving a widow behind. Members of the House proposed to appropriate $20,000 of public money, of taxpayer money, right? Of tax money, because there was no such thing as income tax. Like, it couldn't just tax your wages. Taxes came through the proper tax system, like sales tax, import and export tax, etc., tariffs, all that. So $20,000 of the public money to give to the widow to assure her welfare and to honor the memory of the late officer. Crockett opposed that appropriation in such persuasive terms that it received only a few votes and was defeated. Before you consider him heartless, hear the facts which will show he was just the opposite. Others before him had said that the country owed the departed officer of a debt. Crockett reminded the House of the countless men who had served their county with distinction, but to whom Congress never admitted owing a cash debt. In Crockett's speech before the House, he said the following. Now listen, this is so important. Mr. Speaker, I have as much respect for the memory of the deceased and as much sympathy for the suffering of the living, if suffering there be, as any man in this House. But we must not permit our respect for the dead or our sympathy for a part of the living to lead us into an act of injustice to the balance of the living. I will not go into an argument to prove that Congress has no power to appropriate this money as an act of charity. Every member upon the floor knows it. We have the right as individuals to give away as much of our own money as we please in charity, but as members of Congress, we have no right to appropriate $1 of the public money to give to somebody else. Yeah, that's the whole point. He says some eloquent appeals have been made to us on the grounds that it is a debt due the deceased. Mr. Speaker, the deceased lived long after the close of the war. He was in office to the day of his death, and I have never heard that the government was in arrears to him. This government can owe no debts but for services rendered and at a stipulated price. If it is a debt, how much is it? Has it been audited? And is the amount due ascertained? If it is a debt, this is not the place to present it for payment or to have its merits examined. If it is a debt we owe more than we can ever hope to pay, for we owe the widow of every soldier who fought in the War of 1812 precisely the same amount. So I'm not going to go too much further into it, but, well, actually, I will here. There's a woman in my neighborhood, the widow of as gallant a man as ever shouldered a musket. He fell in battle. She is as good in every respect as this lady, and is as poor. She is earning her daily bread by her daily labor. And if I were to introduce a bill to appropriate $5,000 or $10,000 for her benefit, I should be laughed at. And my bill would not get 5 votes in this House. There are thousands of widows in the country, just such as the one I have spoken of, but we never hear any of these large debts to them, right? Hear of any of these large debts to them. Sir, this is no debt. The government did not owe it to the deceased when he was alive. It could not contract it after he died. I do not wish to be rude, but I must be plain. Every man in this house knows it is not a debt. We cannot, without the grossest corruption, appropriate this money as the payment of a debt. We have not the semblance of authority to appropriate it as charity. Mr. Speaker, I have said we have the right to give as much money of our own as we pleased. I am the poorest man on this floor. I cannot vote for this bill, but I will give 1 week's pay to the object. And if every member of Congress will do the same, it will amount to more than the bill asks. Maybe we should suggest that Congress do that from their own personal coffers for all the welfare recipients, because that's the whole point. That's how you know we're under a trust indenture, part of a membership corporation, and what I like to call communism light, because when the government can take from you at gunpoint your personal property and give it to someone else and call it legal, okay, you have to be under a national trust indenture for them to even consider it quasi within their power to do. So that brings me to this point. So there's been people posting, and I don't want to single anybody out, posting on posting on Facebook, and some of them are my followers, and I get it. You know, it's people understand the system just enough to see how it works, but don't understand the fundamental aspects of it and the fundamental principles at law that are unwritten, right? Such as administration and dependence. Okay. And so I'm not trying to single anybody out, but I had this post I just wanted to show, and it's nothing I like, you know, this individual, I absolutely like what they post most of the time and stuff like that. And I understand their anger at the situation, right? But this comes from a fundamental misunderstanding about dependence and accepting benefits. There's no such thing as a free lunch. As soon as you apply, which means to beg, it does, apply, right? Apply for some sort of benefit, you automatically come under the administration of the entity giving you that benefit, especially if it's for survival. Okay. So I have to check that video out. It says fact number 1, SNAP is not funded by your paycheck. It's funded by bookkeeping entry created by the Federal Reserve and backed by U.S. Treasury obligations. Translation, it's created out of thin air through congressional authorization. No, Karen, your 22% tax bracket didn't feed a family of 4. Wrong. That is 100% wrong. No. Do you know how they're able to do the double ledger bookkeeping system? Every negotiable instrument has to have security. Do you know what the security is? The sweat equity of all 14th Amendment citizens, the mortgage of your property rights now held in trust, okay, to be able to appropriate money using you as the surety from the central banking system to provide programs like these. The acceptance and indulgence and engagement and welfare programs perpetuates the trust indenture system. It is what it is founded on. It's what it thrives off of. The offer of benefits and protection. Okay. Now, Federal Reserves are not redeemable and receive no backing by anything. And she's not the only person who's posted this, so I'm not singling her out. I've seen quite a few people post it, so I had to correct it. That's why I saved it in a file says display incorrect, because you guys have to know this stuff in order to accurately, in order to be able to effectively fight them. You have to know how they were able to set the system up. You're right in the sense that it's funded by a double bookkeeping entry, right? Credit debt ledger system, okay, or debt or liability ledger system. But there is backing. It's not created out of thin air. It's created against your estate. It's created by a mortgage against your estate. It's created by the promise that they're going to be able to generate revenue off you throughout your lifetime. That's what it's created by. Okay. So yes, it doesn't come directly from the tax. That's true. But the guarantee that they will be able to tax is part of the security that allows Congress to appropriate money from them. So it's the same thing. Anyways, so it says Federal Reserve notes are not redeemable and receive no backing by anything. This has been the case since 1933. That's also not entirely true. So if you read the congressional record, which I've showed on here, many times, March 9th, 1933, internal debts within the nation didn't have to be backed by gold. They were not redeemable in gold after the gold confiscation and all that, right? But international debts had to be paid in gold. So there was actually a situation where France asked for its money back, right? Started to get suspicious about whether or not we had it. And there was a whole big international diplomatic debacle about that right after we got taken off the gold standard. They were like, wait a minute, you're going off the gold standard. Well, what about all these bonds we're holding? We'd actually like to go ahead and redeem those for gold. And we're like, yeah, well, I mean, that's cool, but we don't have it. So what are you going to do? That's pretty much what happened. And we had built a big enough stick with the military, and pretty much they just kind of had to accept it. They're like, okay, then I guess we'll just hold these bonds because we're definitely not going to go to war with you. But that's also right. And in the 70s, the United States became insolvent, which means unable to satisfy its debt. And now we have just been existing in a state of insolvency since then. So, and all the money powers know this, and I do not know how economists have no idea. It's because they don't have any idea of history or how money actually works. Most of them, some of them do. But anyways, under the new law, money is issued to the banks in return for government obligations backed by the credit of the nation. Yep, that's in there. Absolutely. But more specifically, what happens is, okay, so it's in 31 Code of Federal Regulations. The banks act as a custodial intermediary. What they do is when you go and you sign a negotiable instrument, you have a security drawn in your name and you sign it, right? And the bank then goes to the Treasury Direct account and they exchange the securitized security for the equivalent in debt securities that are legal tender. Those debt securities come from what's called your minor account that you have no access to. And this is the one that the Fed puts funds in, right? And I think that's secured, though I haven't found absolute proof. All roads lead to Rome. So I think that's who that's secured by. And it would have to be because it's a public charitable trust. The Social Security is. It's public charitable trust. And so that has to be a church. So anyways, so they put it in the so they take the security, they go to Treasury Direct, and they exchange it. They use it to pull the funds from your minor account. It's your credit that they're pulling for you, but you need this custodial intermediary to access your credit because you're considered an infant pauper without free will, right? You're considered incapacitated. So they essentially act as your custodian. That's what it's called in the Code of Federal Regulations. And they pull from your minor account into their primary account. And then they turn around and they give it to you as if it came originally from their account so they could charge interest on it. Now, the interest is interesting. The Fed always charges interest on money that comes from the minor account. And we know that interest rate. They talk about it all the time. It's like the 3% or whatever it's at now is the Fed interest rate. That's the cost of money or the cost of Federal Reserve notes because there is no money. And that's the cost to the banks, essentially, right? Even though it's your credit, but it's really the cost to you. And what the banks do is they take it from your minor account into their primary account, and then they add their own interest on top of the interest that has to be paid to the Federal Reserve. So say the Fed charges 3% interest, the bank charges you 6%. Now both the Fed and the bank get 3% on allowing you to access credit. And there's nothing of value actually given. And there's nothing of either the Feds or the banks given to you. So the real thing to attack here is the fact that there's no lawful consideration to create a valid contract. So therefore the contract's null and void. I actually just did an offer of conditional acceptance for one of my wife's creditors. Maybe I'll show you from years ago. See, since they got the interconnected system now, stuff's popping up probably for you guys too. That was like been years and years and years. You forgot all about it and boom, it's popping up. So offer of conditional acceptance is basically the fact like, hey, I will accept the debt or I will fulfill my obligation, my financial obligations, if you can prove that a debt actually exists, that the original creditor actually gave something of their own out of their own account and experienced a loss. If you can prove this, then I will satisfy the financial obligation. If, for instance, you erroneously acted as a custodial intermediary to access someone's minor account, who is unable to access that account themselves, and then turned around and gave that and transferred those funds into your primary account, and then gave those funds to the individual as if they were your own in order to charge interest and fees on them, well, there would be no lawful consideration. You will have given nothing of your own, and therefore the contract will be null and void. It's a fact. Okay. So anyway, this SNAP is a direct legal obligation in the United States. Yeah. Okay. So look, because this entire system is set up on fiduciary foundations so there's a paper I show all the time. It's called Fiduciary Foundations of Administrative Law. Now we're in one big trust system, and the whole purpose of this trust, this administration of incompetence that's taking place, the 14th Amendment citizen is an infant, Title I, Section 8, Born Alive Infants Act, make all 14th Amendment citizens infants. Just read it. I've shown it many times. And because of that, the government has to act as a parent. And everything that it does, its parents patria, and everything that it does has to be for the benefit of the people under its wardship, right? It's infants, it's enfranchisement. So the only way it would be, it's a legal obligation to provide benefits in exchange for the mortgage of your estate. That makes sense, right? Because that's part of the terms of the original contract between the banks, Congress, and the president. They only could mortgage your estate for your benefit, to provide you benefits. So the provision of benefits is essential to keep the scheme going. And then they create NGOs and nonprofits to funnel the public money into private pockets. But the whole point is writing something like this is supporting the trust indenture system. You need to become independent of the government. That's all I want to say. I'm not attacking Angel here, and I'm not attacking anybody. And I've just seen some people post this, and I really just want you guys to realize what it is that you're actually saying. You're saying I am an infant. I am incapable of providing for myself. And so therefore I'm unable to be sovereign and free. And I do want to be under administration. That's what you're saying. And if that's true, I mean, this isn't the country for it, because we're not supposed to be that way, as we just read in that Davy Crockett story there. But, there's plenty of countries that love taking the entire citizenry under administration and then controlling every aspect of their lives, like China, for instance, or a state like that. So with that, or Canada, for instance, right? So with that, I'm going to go ahead and get out of here. I appreciate you guys. Oh, Chuck Porter, status correction. Yes, this is something we do in the Jurist Society. Also, I was meaning to ask, I'm thinking about extending the Jurist Society to Facebook if anybody's interested. That's where we actually do status correction. I've already corrected my status. Many other jurists have as well. You claim your estate on the record, create your house and seal, give yourself, and the claim of the estate is also a performance contract, which I'll get into. I have gotten into in other streams. It's essentially what it does is just like your tech contracts, where, like your websites, by using this website, you agree to the terms of service and cookies and etc. And you don't have to hit yes or I agree or any of that stuff. You just continue using the website, and it's tacit agreement. The claim also has performance contract like that puts them on the hook for 30 mil. So outside of that, though, the most important thing is that it gives you the lawful standing. It's expatriation from United States citizenship. It restores your standing as one of we the people and gives you the actual standing to do like Ryan Michael Thor did. Now, with that being said, you can still do what Ryan Michael Thor did. I don't know if he's corrected his status or not, but he kicked that judge's ass. So, but this is where the law that I teach on here is more for general, like general audience of people at all different stages of learning the truth of what's going on. And then the Jurist Society is for people who are, serious about learning the law. So that's what we do. And so I'm thinking about bringing that to Facebook if anyone's interested. I've got tons of treaties, including the ones I went over today in the Jurist Society mega folder, tons of templates for at-law declarations to file at-law counterclaims, teach you how to use the at-law counterclaims so basically when they try to bring you into equity, you take them to law for trespass on the case and attempted administration of your estate. And you say, hey, not only do I not believe, but the fact that you're doing this is actually causing a harm to me. And that's what one of the Jurist Society, I'm not going to name him, but he had done last year and totally threw a freaking nuclear bomb right into the situation there. And of course, that is a euphemism and metaphor, YouTube and Facebook and everyone. So don't sit there and try to flag me for using that terminology. But it did. It rocked the courtroom. Very impressive display. And that's the type of stuff we do there. Also, with that being said, I will try to do another stream before I leave for Quartzsite, Arizona, but I'm leaving next Tuesday night for Quartzsite, Arizona. So that's why streaming has been sparse preparing for that, to do the presentation down at International Truth Expo. So forgive me if I do not stream beforehand, but I will be streaming from Quartzsite. So, you know, there's that, and that should be pretty cool. It's going to be not just the law and the stuff that I talk about, but also pretty much every other facet. There aren't multiple conspiracies. There's just one big conspiracy, and they're all ultimately related to subverting the law and enslaving you in a technocratic, neo-feudal communist system. So with that, you guys let me know in the comments if you'd be interested in me extending the Jurist Society to Facebook as well, and I would be more than happy to do that. But other than that, you guys have an awesome Friday night. Have an excellent weekend, and I will see you on the next one. Later.